So yeah, I mean, this slide is just to illustrate, how IP really can be used as a business tool. We like to give sort of quite holistic advice when we're advising someone on their IP. This really can be the core of the value of your business. There's a recent study brought out by the EU IPOs, the EU Intellectual Property Office, and the European Patent Office, where they conducted a study over a 10-year period and found that as SMEs with registered intellectual property, so that was patents, trademarks, and design rights, generated 44% more revenue per employee than their counterparts that didn't have any registered IP. But actually, less than 10%, it was 9 point something percent of SMEs actually owned registered IP. And actually just larger firms as well, I think it was about 16% more revenue. There's some interesting stats in that. It's an interesting report. If anyone wants to read that, we'll be happy to pass that on. But having these rights really did just give an economic boost to those companies. There's government incentives around having IP. So I don't know if everyone's looked into patent box or indeed tax credits. These are tax breaks based on your IP. These are rights that you can buy and sell. Is property right, registered IP. Licensing, this is often an underused tool. So, having registered IP means that you can license that out exclusively or non-exclusively, widen the reach of your business. Economically, there's some companies that only license IP and don't actually manufacture anything themselves. Investors, we quite often find that clients say that investors want to know that you've protected their investment, basically. There's also funded IP audits. We take part in these for Innovate UK, where one of the issues as well we find is that people don't necessarily know what IP they have and what sort of options they have and how to protect that, which we'll go into as well in the talk. And yeah, competitive advantage we've talked about as well already with this report that said that the EU IPO and EPOs brought out. But yeah, it can really add a lot of value to your business. Just thought useful to have just a summary slide. It can often be quite confusing of what the IP rights are, what they cover. A lot of these are actually overlapping, but just as a basic overview, excuse me if this is already familiar to you, but so patents basically protect technical features. This could be a product, could be a process, but there has to be some technical feature that's what a patent covers. These last for 20 years if you can get these protected with a granted patent. And the idea is that by getting this 20-year grant of protection, you then after that give your rights your invention onto the world, and can forward innovation as a society, and that benefits other people. Trademarks, they protect branding. So this could be your name, a symbol, basically anything that identifies what your product is. Designs, these protect the appearance of a product. Again, we'll go into all these in a bit more detail shortly, but these protect something different to patents, but you could have both of these on the same product, for example. A lot of these will cover the same product. And copyright, so these protect literary, dramatic, musical, artistical works. Again, it's just listed there, sound recordings, films and broadcasts. These are automatic rights that just arise from quite often in the creative industry, but there can be copyright on lots of different things. And then trade secrets and confidential information. These are more something that you might want to think about incorporating your IP strategy. These aren't registered as such. So, these are something that you'd have to think about what is right for the information you're trying to protect. So, I mean, the advantage of a trade secret, confidential information, technically, you could keep that forever, but actually if that gets out, you don't have any formal registration for that. Famously or infamously, the recipe of Coca-Cola is thought to be protected by a trade secret, so that nobody knows what the recipe is. But obviously the danger of keeping this as a method of protecting your IP is, if one of your employees leaves, will they take that with them? It's sort of some more risks involved, but potentially, you could just keep that forever. But is there any way somebody could reverse engineer what you've put out there? So it's a bit more uncertain, and that can. It might be the only way you can protect certain things as well, those. But this is the sort of the conversations we can have with you. And we like to use Coca-Cola bottle there as an example of how there's lots of IP can occur in one product. So, I'm not saying they do have patents, but you could potentially have a patent on a new method of creating some extra fizzy drink, or the trademarks. There's lots of trademarks there in the Coca-Cola portfolio. Designs, you could protect the physical shape of the bottle. Copyright, as soon as you design a brand in the first place, there's copyright in that. Trademarks can protect. There's actually quite a range of things you can protect with trademarks, but obviously everybody has a trademark. And the danger quite often with this is that people maybe think of it as a bit of an afterthought, especially if you're very focused on your product, but it is really important to get this sorted from early on. Just to example what trademarks cover. So there's words you can cover with trademarks. So, do the individual letters, quite often you would start with that to give you a broader coverage. But just the design of the word itself, you see that Tesco logo there. It's the stylized formation of those letters can be protected as a separate trademark. Protect letters and numerals. Colours, the Louboutin shoe, that's a trademark. The placement of the red on the sole of the shoe is a trademark. You can even protect sounds. These are more tricky. Basically, it needs to be capable of being represented on the register to be protectable. But the shapes of goods can be protected by trademarks. So again, there's some overlap there with designs and copyright. But the point of a trademark is that somebody is able to tell that is your product. Without trademarks, really anyone would just be able to use any name on anything and be very confusing for the consumer. It's not helpful for you. How do they know that you're buying a product again from the same person? It'd be very annoying to walk into a shop and not know actually what you're buying. Like, that's the whole point of having a mark on there, and that's the reason that you would trademark for you and for the consumer. So it's a badge of origin, a guarantee. We all choose based on different things of what we're going to buy. Quality of products might be cost, but you know what you're buying because of that label on there. One thing really to be careful of is just choosing what name and symbol, anything using for your brand. So things that are very difficult to register are descriptive words. Quite often people will choose a word based on what they're doing, but actually to get that registered, it's one of the trademark laws, is it should be non-descriptive and it should be distinctive. There's different slightly, say there's different elements of law to be aware of in different countries. I mean, different words can mean different things in different languages. That's something to be aware of. If you think about going abroad, you can be caught out by that. There's protected out emblems. So the Olympic rings, for example, symbols of the crown, you're not allowed to register those. So the last thing you want to do is invest into a name or a symbol that then, down the line you can't actually trademark it. So it's really important to think about that early on. Anything offensive, again, there's different levels of this in different countries, but you're not allowed to register these elements that are considered to fit into these non-registrable categories. And also, just really important is to search that no one else is using it. These can really trip you up. So this is the sort of thing about trademark law itself. Without having ever thought about trademarking your own brand, you're basically under trademark law. You could be subject to trademark law just by using your name in trade, because if somebody else already has that, they can stop you using it. Yes, it's just a brief overview of the trademark registration process. The process that we would deal with on your behalf if you were to employees to go through the process for you. So it's a series of tasks that are all deadline driven. So it's an interaction with the trademark office. Again, really important, what we'd say is a search at the start. A professional search is always going to be more thorough. But is somebody else already using it for what you're doing? So basically, it's a similar or same name for or brand for a similar or same services. But if it's a really famous brand already, you'd have trouble with whatever you were doing. But it's a quite an involved process, and basically the later stages of getting through these are made better or easier to get through if you've searched and you've given yourself the best shot with the mark that you've chosen. Because basically when that registration goes into the office, they will search on the register and they will contact everybody who has a similar mark to you in a similar area, and they all have the option to oppose what you're doing. So if you've started with something that overlaps with what a lot of people are doing is very similar, you're obviously going to come with more problems, and that's when your costs can really rack up as well, and just it can be quite stressful. If you've come up with it's difficult because trademark registers are getting more and more crowded, but the more distinctive and prepared you are at the start with the mark you have, the better chance you have. This is all about reducing risk later on. But so this is the sort of thing that we would do on your behalf. Or trademark attorneys or experts at drafting specifications, they will try and as well just to avoid any pitfalls in there, make sure it's covering everything that you think it is, because that's the last thing you want is to get through everything, think, right, we've got a trademark registration, and then there's something missing from your specification or some loophole that someone else can take advantage of. And it sort of gives you a false sense of security. But yeah, it's all about risk reduction. It's almost like insurance for operating your business. And then, yeah, they basically can last forever, trademarks, which is great. Every 10 years you can get these renewed. There was a recent case actually as well, Sky and Skykick, about filing in bad faith. So this is all going to be important in having that specification drafted. Basically, the office is going to want to know that the goods that you have put in your specification are ones that you're actually going to use. So this was a bit of a landmark case recently on that. So it's going to be harder to just put a big list of everything and hope that nobody will have an issue with that. But the benefits of this, you can stop someone else from using or registering your brand, your mark. It can protect your investment in whatever product you do. And the last thing you want is somebody else to be able to operate under your name after you've spent a lot of time, money, and effort sort of building up your reputation. And yeah, renewable indefinitely. Apparently, the trademark one is still in operation. Every 10 years in the UK and in most countries of the world, it's 10 years. There's some exceptions to that. You pay a fee and then you've got it for the next 10 years. You can use the R symbol, which can be a deterrent for the people to copy as well. Once you've registered, have a registered trademark. And against commercial assets, you can license it, transfer it. We do IP valuations as well. It can literally add value. How much value is in that Coca-Cola brand name? It's so instantly recognizable. You want people to be able to associate this with you as a high value element of your business. And it gives you, importantly, legal rights against infringers. I come across a lot of people who are really angry, that somebody's copied what they're doing, but actually they don't have anything to then come back with. There are unregistered rights that you do have some rights that you can accumulate just by using your brand, but it's really difficult to enforce in court. The strength of just having that piece of paper that literally has a list and a picture or a name of what you've done is so much stronger and easier to enforce. And there are people who will buy brands in bad faith or register brands for purposes that just to stop someone else or stop you because they think your brand is up and coming. Or they've just done that before you have. It saves against a lot of issues later on if you have that. And there's sites like Amazon, for example, that if you can demonstrate you've registered some rights, they will take down some copycats. Yeah, so I don't want to be too negative again on this, but it is just protection against sort of issues that are avoidable. If a third party has registered your mark before you, they can stop you from using it. Again, there is some unregistered rights that you can, or some unregistered rights you can use, but they're just really difficult to enforce. You could be forced to rebrand, redesign. These can be really expensive, stressful, and just a pain. You built up your customer base already, invested, you could have this all over your product. Worst case scenario, you can have your products have to be destroyed, or destroy the trademark that's not yours, that someone else has already registered, or have to destroy that off the product itself. You might have to pay them damages. These aren't situations you want to get into, and they're all avoidable by just sorting your mark out from the start. As I said, the unregistered right is difficult to enforce, and also just if your trademark isn't locked as yours, then you don't want people to confuse your mark to somebody else's. The whole point is that they can tell they're buying yours. Yeah, so these are just a few interesting battles and trademarks you might have seen in the news. Some of these predictable, some not. Iceland, the country, the government took issue with Iceland, the supermarket, because they argued that they were preventing Iceland, the government argued that Iceland, the supermarket, was preventing Icelandic companies from promoting themselves abroad. This is a battle that's gone on for years and years, back and forth. And again, you don't want to end up in these battles. I mean, that's quite an unusual one, but they can last for a long time and be very expensive. So sort of a bit of investment up front can maybe guard against that, but that's a bit more of an unusual one. Elvis Presley and Brewdog. So Brewdog had a beer brand called Elvis Juice IPA, and Elvis Presley's estate took issues with this. And again, you end up in these sort of battles. They can go for quite a long time. WWF, so the conservation charity, they didn't want the connection with wrestling, so they viewed that as unsavory. So that's an interesting sort of dispute, rather than necessarily confusion. It's maybe people don't want to be associated with certain other elements. It's worth thinking about. Apparently, the Peterborough FC, called the Posh, and Victoria Beckham took an objection with this of being Posh Spice. And Hailwood International, so apparently they had a gin called Vera Lynn. Apparently they were arguing that gin was Cockney rhyming slang for Vera Lynn. But Vera Lynn won that one. I think they had to pay some damages. So there's some interesting ones, but yeah, it's worth not getting into these things. This is an automatic, right? There's pros and cons to this. So the fact it's automatic, it's obviously makes it cheap, easy to acquire, but protects a range of things. All these in, let's say, the creative industry. It has to be original, literary, dramatic, so artistic works, plays, books. Interesting, there's copyright and software code, and some web content databases. So, and then also, let's say, creative again, music, films, broadcasts, and it lasts for a long time. So, the lifetime of the owner, the first owner, plus 70 years after that. So you'll see people who might have been, died quite a while ago, and their estate can be worth quite a lot. Songs, particularly sort of, really successful song portfolios can have a lot of value. So yeah, this is one of the myths here that we hear about this, is that, I paid for it, so I own it. If you've paid somebody to design something, they will likely be the first owner of that. Because they've created it and it's automatic. The only way that would automatically assign for you is if that they were your employee. But paying somebody to own it does not mean, sorry, to design something does not mean you own it. So really important point here, make sure that you've agreed who owns what, or just have that written down, check the terms and conditions if it's some professional supplier of services. So even though it's cheap and it's great to acquire this as well, just it can be really difficult, expensive to enforce. So copyright battles are quite difficult. You don't tend to win those disputes. If you're creating something yourself, make sure that your ownership is sort of displayed on, if you've something on your website, for example, put your little C symbol, say that you reserve your rights to copyright. Obviously, with everything online, it's quite easy for people to lift things, but just displaying it is a good start. Keep good records. If you do end up in a dispute in court, that or prior to that. Just having records that you've, your trail of creating something, basically is one thing we really recommend. But yeah, it's a tricky one, copyright, because it can be quite a strong right, but it's quite difficult to prove. So anything you can do to sort of just keep good records is really the primary advice for if you've created something yourself. If somebody else you're working with, jointly creating something with somebody else, make sure you've decided between you, where does the copyright lie, who owns it, is it you, is it a company? Just make sure that's all sorted out in advance. But this is a really common thing that the common example we give is the wedding photographer. The photos they take of your wedding, of you, the wedding photographer owns that because they've taken the photographs. But yeah, that's the classic example we use. Going to talk a little about designs. These are quite often underused, actually. Registered designs, they protect the look and feel of a product. Sorry, some of the words I'm not converted well in the PDF. But yeah, so GUIs can be protected with this packaging. Basically, the appearance of a product is what registered designs protect. So yeah, in the UK and the EU, they're relatively cheap compared to a patent, and relatively quick. These were traditionally used in sort of the fashion industry, sort of get them quite quickly. And if you need to then be repeatedly protecting things, it sort of keeps that chain going. Patents take quite a long time to get granted, whereas these are a quicker, easier, cheaper way of getting protection. You can include multiple designs in an application. Yeah, so in the UK and the EU can, although they need to be in the same class, although those are changing. So yeah, within days or weeks, potentially you can get a registered design in the UK because they're not examined as patents are. And you can get to 25 years protection if you're renewed. These are renewed in 5-year chunks. Just be careful with this. So unlike with trademarks, there's a disclosure period. So basically, there's a period of time that you have to, it has to be considered new, basically. So within the UK, you kind of publicly disclose your design. Within 12 months, you would still be allowed to file for a registered design. And in the EU as well. But this varies from country to country. So in India, you'd only have 6 months after you publicly disclose to file. And in China, there's no grace period at all with that. So it just have to be completely novel. So what we'd advise is really just keeping it confidential until you've filed for a design if you want to follow this route. Because you could be caught out in different countries with this, and in that time somebody could have copied it as well anyway, so there's different advantages to that. But yeah, generally we would advise just keep it confidential.
Good morning, everyone. I just got my thanks to Hermione for organizing, and to you all for joining us this morning. So we've heard about trademarks, designs, copyrights, the main IP rights, trademarks and designs being registered. Patents are the other major type of registered IP rights that protects your ideas. And one of the statements we often hear from inventors themselves is it's too simple, deserve a patent. We've decided not to patent it. We didn't speak to a patent attorney because we thought it's not inventive. But one of the things to remember is that simplicity in itself, it's not a barrier to patentability. It can be a paperclip. Picture here. And can still be patentable if it's something new. So often people put down their own inventions, but patents are there to protect small improvements, small advancements over what's been done before. And patent examiners look at the inventions, all inventions, in the same way. So it doesn't matter if it's a simple mechanical device or complex software system, they're always the same questions. Is it new? Does it have at least one point of difference, spot difference over what's been done before? And is it inventive? In Europe, this translates into solving a technical problem, having that technical advantage, usually when we structured arguments for inventive step. And if it does, then you can get a patent. And what's really important here to remember is that to have novelty, you must keep it confidential before you file the patent application. So a bit like with designs, as Rachel mentioned. After we file it, you're free to discuss the invention. And if you're new to patents and you take away one thing from these talks, please keep your ideas confidential until you've discussed with your IP advisor. So that's another example of a simple invention. It doesn't have to be rocket science to get a patent. Small jeans hanger. It helps with hanging clothes, so it's got a clear technical advantage. It hadn't been done before. So the applicant here filed a patent to stop others from copying it, and B, the other reason was for patent box relief, tax relief. So as Rachel mentioned in one of the earlier slides at the beginning, there can be very good commercial reasons to consider patents, even for the simplest of inventions, and patent box reduction in corporation tax is one of them. And we've helped clients find small patentable features in more complex systems with a view to get a patent in the UK, which may be narrow in scope, but it does serve a commercial purpose, like patent box. So a narrower claim in a patent will give you less protection, but it can get a patent through quicker and at a minimum cost. In that case, leading to patent box. So it's important to discuss from the beginning the strategy with your IP advisor. Be clear on the reasons, the why you want any sort of IP protection, why you want to file the patent as opposed to keeping it secret. Rachel mentioned trade secrets in the classic Coca-Cola example. That may be another valid strategy if you're very sure that nobody can reverse engineer. So that's just some further examples of products that can contain patented technology. Patents can protect products or processes. And in these examples, the typical products that you might expect would have patents associated with them, alongside other IP rights like trademarks and designs. But again, it doesn't have to be complicated technology, as long as it's new and it solves a technical problem. And when we draft patent applications, we need to include a very detailed specification, so and a description of what the invention is and how it works. So we usually include more detailed figures, drawings to show the invention. And the method patents, which is usually how we draft software patent application, would include flowcharts to describe the processes, computer implemented processes step by step. So more mythbusters. You can't patent software. Was mentioned at the beginning. So, Patents Act does say that programs for computers, also algorithms and business methods, are excluded. But the law also says that they are excluded only to the extent that the invention relates to programs as such. And now the meaning of as such has been debated and has evolved a lot through the case law. So we've got more guidance and clears on that. It varies from country to country. So that's another thing to keep in mind. Where are you going to file a patent? Because patents, like other IP rights, they're national rights. In Europe, it as such usually means that it solves it relates to the question of whether it solves a technical problem. So for example, control software. So one of our clients based in Cambridge, they develop software for controlling industrial inkjet printing systems to print on 3D shapes more accurately. And another example would be a software application for a blockchain application layer that make the communication more secure. So accuracy, security, these are considered to be technical advantages, which can lead to software patents. Software patent applications do require careful claim strategy, and drafting is more challenging, but certainly possible. And that includes AI. So this is an example of one of the patents we obtained for Peter Brady and Virturi. When we started working with Virturi, we started off with a funded IP audit that Rachel mentioned is available. And I'm sure a few of you here, at least will know, Peter will know about Virturi. They're a great example IP strategy done right. We obtained granted patents in UK, US. They're still pending in Europe, where it takes more time. And so Vittori developed virtual AI digital assistants with highly realistic human avatars and fast responses with applications in digital healthcare. And from a patentability point of view, what matters is whether the software solves a technical problem. So the same key question asked by examiners is it software, but does it make a technical contribution? In this case, it did. The video technology is improved. The AI algorithms that they help provide fast, more accurate responses. And then the two technologies are seamlessly combined. So it considered a technical advancement. When it comes to software and business methods, it's worth bearing in mind different countries, different approaches. So have that strategy of drafting in mind before you file that first application. We developed some sort of strategy. Feel free to contact us if you've got some software that you've developed and you're unsure about your IP strategy. We're always happy to have a chat about how you might be able to protect it. Next slide, please. So it's hard to give a talk without mentioning AI. This graph is a bit out of date, only up to 2022, but you can see the exponential trend, which kept going in AI patents, not just filed, so applications, but granted patents worldwide. So on this point, I'm going to refer here to statistics that I've heard from Peter Brady mentioning in one of his recent talks, that Suffolk has the most granted AI patents than any other region in the UK. It's not a well-known statistic, and it's a great highlight for the region. In line with this trend. So, just briefly looking at patent timelines. The patent application starts with the first filing. The filing date is important. As I said, it plants the flag in the patent system. And as mentioned earlier before, it's important to keep your invention confidential. It is the date where you're free to disclose the invention to the public, so you don't have to wait until the patent is granted. And from the moment you file the application, you have pending patent protection. You have a year to request search. You don't have to spend anything in official fees straight away in the UK. And applications don't get published straight away. They're typically 18 months, unless you accelerate publication and accelerate proceedings, depending on your strategy. You have this option. And in the UK, it can take about up to 4.5 years. Our record, I think, was about 10 months, maybe a year with acceleration request. And once granted, you get up to 20 years of monopoly, subject to payment of renewal fees at the patent office each year.
So I'm just going to talk a little bit about IP strategy. So briefly touched on this, that IP rights are jurisdictional. So in different countries have slight variations on their IP laws, but just generally you can only enforce your IP rights in a country where you've registered those, or if they're an automatic right, where those have arisen. So generally what would happen is our clients would register in the UK first, or in Europe. And then for patents, trademarks and designs, that sets off a system where there's international agreements in place whereby you've got a set time period on which to file abroad based on that first application, and those other countries will respect your first filing date. So for patents, that's 12 months. So within 12 months, if you file anywhere else, pretty much every country has a patent system. You can file another application there. Some advantages there is that you can potentially, add some improvements. Quite often we'll go into like an international application called a PTC within 12 months, so you can maybe add some improvements in there. But otherwise, you can't add to patent application once you've filed it. And then these multinational systems can be quite handy to then give you a bit of extra time to decide where you want to, which individual countries you might want to take forward your invention into. There's also a European equivalent of that as well. And trademarks, you have 6 months for the same. To file abroad after your first application based on that first one. Difference with trademarks, you could still file again file after that 6-month period, but then there's a danger that could be intervening rights in that period if anyone else has filed. If you've not made use of that, we call it priority period. But yeah, there's a lot of elements. Think about where you want to protect. So, you know, your market states, but also your manufacturing states, you know, which countries might you want to go into. This can be difficult because you might not want to know where you do want to go to, but these are time limited decisions that we can help talk through with you. But some of this will just be, you know, your commercial strategy of where you might want to go to, which can be a difficult decision to make early on. But as particularly with patents, it's sort of a now or never decision at that point. Yes, this is really a summary of things we've discussed. So, you know, takeaway points from the talk really. One, really, really important, keep your technical information confidential. You know, the patenting process, it can be challenging. There's a lot of elements to it, and we'd help you through it. But actually, one of the most painful ways to not get a patent is you've disclosed yourself and given away your information. We've had search reports back from the Patent Office with clients' Facebook pages where they've just put their design online. Everyone can be really excited about what you're producing, but actually that means you potentially can never get a patent. And you know, all the other ways that you might be able to stop getting a patent, giving away yourself, is really sort of easily preventable. Really vital for patent applications, but so we also discussed design applications. It's important to think about that as well. And IP ownership in writing, agree these before you start working, before you start any collaborative work. It's really complicated after you've started. It can be really complicated, it can be expensive, and actually it might just not be possible to untangle some of these situations people end up in after the event, especially things like copyright or automatic. You know, there's multiple inputs into there, or, you know, especially if something starts to increase in value after, you know, your business starts to get more and more successful. You know, whoever actually has the rights to that might not want to give you that back, or might, you know, you might have to pay for it in a way that actually, if you sort it out in at the beginning, wouldn't have been an issue. Having policies in place, you know, employees, haven't touched on this so much, but actually, if you've got employees, they will working for you and create something in their employment in the course of their duties, you would own that IP. But it's as well to have all this in place in contracts. You know, what happens if somebody leaves? You know, if somebody has got a trade secret, you know, who's got access to these? Do people know that they shouldn't be sharing information that you've got in your company that's of value to you? All these things, just having them, and it seems like a really formal thing to do, especially when you're sort of working somebody in a sort of relaxed way at the start. But that's the time to sort these things out. And really, really important on your trademark, check your name is available before you've started using it. Is it available? You're not infringing somebody else's rights. Is it registrable in itself? Would you ever be able to get a trademark for it? And how well is that specification being granted? There's no point in having a granted trademark unless it covers everything that you think it does, and yeah, guarding down the line. So all these things, say, we can help with as well, but yeah, it's all about protecting yourself up front, and just seek advice, just talk through, see what your options are, and then at least you can make an informed decision. Next slide, please. I think we might be near the end. Oh yeah, it's just a summary. But I feel we've gone through sort of those are the major IP rights. You know, patents, trademarks, and registered designs, so the registrable ones. Copyright in the UK isn't registrable. So like the US it is, but there's other variations there. Licensing, as I said, is quite underused. It's worth looking into. We deal with litigation and mediation. I say more things don't go to court, but we can deal, you know, if you do ever receive something where somebody has said that you're copying what they're doing, for example, don't ignore that. And it's advisable to just seek professional advice before you can respond to things like groundless threats you can get involved in, where you can get yourself in trouble if you respond in the wrong way to those. Just your general strategy, you know, let's say once you've filed something, it kicks off a timeline that you really need to be aware of at the start. IP audit, something Innovate UK can offer grants for, that we operate, and also you can tailor those to how you like if you independently instruct one of those. Valuations, you know, maybe when you're buying or selling your business, you know, how much does your trademark add to your business, or patents? These can all be valuable. Agreements is something we can do as well. If you are collaborating with somebody and want to sort out who is going to own what, that's the sort of thing that we can do as well. Clearance searches, make sure it's available to you. So we can do these on patent side of things as well. As somebody else already done what you're doing, it can save, you know, it can help us draft the patent accordingly to what's not we know isn't already out there, and you're not. It's again stepping on his toes, trademark side as well. Competitor watching we can do, and introductions to, for example, Innovate UK, advice, things like that we do, or anybody who, you know, might be working in your space that we can be helpful for. We like to introduce people where we can in that way, just to, there's a value add for, when we come across. So it's just, Has anyone got any questions? We're happy to take those. Hopefully that's been a useful introduction. It covers so many things IP, it can sort of go on forever, but if there's anything particularly you wanted to ask, feel free.
My son, he trademarked a name and in the UK, and then subsequently while he was filing, the same name came up on a website with TM beside it in Brazil. Has he any rights there, or is he behind this company because they've got TM on it, or what's the difference between TM and the C? He just doesn't know where to go.
That's so gone.
Sure. So R is usually the symbol for a registered trademark.
All right. Okay. Yeah.
The C is the symbol for copyright. Now, if he's not filed a trademark in Brazil, then he probably wouldn't be able to enforce his rights there. Unless he's gained some reputation. It's worth looking into where this other company or trademark are acting, whether they have equivalent rights in other countries, which might be of more commercial interest. Is Brazil a country of concern for your son?
It's not, no.
But he's noted that there's something there. So it's worth doing some searches on that specific company and see where they might have rights.
Okay.
But using the symbols, it's a good way to signal that you've got rights.
So can I just start using the copyright symbol next to my logo without having to pay anything?
You can use a copyright symbol, yes, for original contact on slides, for instance, or always you'll see it on websites.
And that gives my brand a certain level of protection, even though it's not a registered trademark.
It signals that you've got protection of IP rights. Copyright is an unregistered right.
Oh, okay, Michelle, that would be good. So Michelle, because Michelle's got a product that she wants protecting, but obviously we want to start getting it out there into the world and marketing it. So she can start using the copyright logo next to her brand. Is that right?
So the copyright is in the artistic creation basically of that word or that logo. So if you're using it as a brand, you'd be wanting to use the TM. So that's showing that you're using it as a mark for your goods and your services.
Can I just start using that TM next to my brand today now, or do I have to go through the process?
Yeah, so when you've registered it, you can start using the R, which is the stronger protection, but you could put TM to illustrate. I mean, it's not necessarily, it's not, it just shows, it's just an indication, but it's the R that will be enforceable, legally as a registered right, which would be the stronger right.
And how much is it to register it with R?
So, it depends really. So, it depends how smooth the process is. Probably looking at with us, maybe about 1,200, maybe 1,000, 1,200 for the process, providing it's sort of a smooth process. But again, some of these is guarding yourself against things that happen that, you know, preparing yourself up front with a good mark, if you like, because it's what bumps up the costs is back and forth if you have to argue with somebody.
So I can't put the R next to my logo until we've gone.
Not
No.
yet.
Process of being protected at the moment. So can I get it registered and trademarked now then? Is that what you were saying?
Just they're saying with them it will cost around £1,000 to £1,200 to do it with them.
I think it's worth
Okay.
looking at having a chat with one of our trademarks attorneys, because the cost will really depend on how many classes of goods and services they want to. Michelle, you want to protect this, so we need to have a chat about your business and find out what are the right classes for goods and services, because that will determine the level of complexity of a trademark specification, which would determine the costs. And where are you filing? Is it just UK? Is it Europe? Is it other countries? So again, yeah, talking about IP
it's
strategy. Europe.
Yeah, that'd be different as well, because it's different
Yeah.
official
Yeah.
fees as well. So we pay official fees, but that's dependent on the number of goods and services you're doing and where you're filing. So that is different as well. So we'd have to look at what you were doing to give a proper estimate for that. Because the official fees are, we add them up separately for different elements of what you're doing. That's variable.
You mentioned about certain words aren't trademarkable if they're descriptive. The name of my company's got two quite common names in it. So would the strategy to be take the logo with the name and kind of trademark the look rather than necessarily the company name, or?
I mean, you can have. We generally say advise starting with the word because it gives you the widest protection. Because if that, you know, is ingrained in other people's marks, you can sort of have a bit of coverage there. I mean, the best way is to try and just pick a distinctive name. I mean, you can trademark your name within the logo as well. That's certainly something we'd also recommend. But yeah, we'd never recommend necessarily using a name that's not registrable. But it depends. I mean, it might seem common, but sometimes a combination of two common words it doesn't necessarily, being a common word in itself doesn't necessarily make it unregistrable. It's more if it's descriptive of your services. But there are a lot of grey areas with that as well.
Okay. Yeah, when I searched it, it doesn't come up together very often at all. It's just theoretically it could be used in a slightly different manner to, you know, describe certain behaviour sort of thing. And I hadn't really thought about it until you were saying about.
I mean, there's different ways to assess this. So there'll be just a general conceptual, you know, impression that your name gives, or how it sounds when you say it, how many syllables they have when they're comparing different things.
Is there a way to sort of have an initial conversation with you guys about maybe pricing up, you know, going through the IP strategy, etc.?
Of course.
Can that be arranged?
Of course.
Just by the email or?
Yeah, I think they've just been popped in the chat or email addresses. But yeah, I mean, it's in terms of, like, say, cost for anything, it is all very specific because everyone's doing different things, and, you know, depending on what sort of goods and services you want to protect. But yeah, feel free to get in touch.
Okay, shall we?
It's going to depend on where you want to go, and, you know, you can stage out your costs for different places as well. It's quite variable depending on what you want to do.
No.
But no, it's definitely worth having that conversation. Yeah, we're very, very happy to have
We're
a chat.
always happy to give the first half an hour of sort of initial.
Okay, yeah, that's great. So, thank you.
First of all, on the trademark front, we self-registered Verifleet as a trademark in the UK, and it went incredibly smoothly. So we did it ourselves, and we've been granted it. So that was quite good. We're pleased with that. The thoughts I've had on the patent front. So, like everything, there's massive lead times on stuff, right? So where my head is, you know, if you have a novel idea and you kind of need to keep that confidential until you start this process, you're kind of losing out on important time to lead on that, if that makes sense. So I guess there's an element of risk where you pop up with novel ideas, push them with the confidence that you will be the best at it, versus having that protection of a patent against it, but not being able to pop up so early.
Sorry, just to understand, so you're talking about the merits of patents and whether it's worth.
Yeah. So for example, we've got. So I'm unaware of any. So we have a fleet management platform that we've written from scratch, and I'm unaware of any other fleet risk management platform that uses AI in the way that we do. So we have our own bespoke AI engines that do certain things with vehicle data to risk profile them, and I'm very sure that we're unique in that field. Now, with those novel ideas, we could hide them and go through a patent process. But I think where we are is we want to pop up with the ideas. You know, time is of the essence with us because we can't wait 24 months to find out if we've had a patent granted. So what we're doing
You
instead
don't
is,
have to. You don't have
Right,
to.
okay.
So from the moment of the filing application, you've got pending patent rights, and you can go to third parties, but you need to have the application filed, not granted.
Yeah. And what kind of time frame are you talking from, like an initial engagement to filing a patent?
Well,
I
we've
guess there's
done
no one size fits all, is it?
applications,
Yeah,
4
yeah.
applications in 2 days by engaging the whole team where there was an urgency. So
Right.
we typically would like about 3 weeks.
Okay.
I would say to have from your instructions and
Yeah.
have time to write a first draft, discuss with you any questions, any clarifications. We only file once you're happy with the application being correct and complete, and we're happy with how the claims are structured. So we would say on average about 3 weeks from engaging with us.
And then and once it's filed, you can pop up with these novel ideas and you're protected.
So once it's filed, you've got protection for what is in the patent application.
Right. Okay.
Yes.
Okay.
But you can't enforce on that till it's granted, but it just starts off the clock. So you've got the earlier right of anybody else.
Yeah.
But obviously you have to get it to grant for it to be a valid patent.
Yeah.
You don't have to worry about NDAs, confidentiality agreements, unless you make changes in that year. So as Rachel mentioned, you have got ways to not to add to your existing application, but to other applications going forward. Say if you were to file an international application which is backdated to your first filing, then you can take into account the examiner's feedback from that first year for your first application and then add things if you've made improvements. But really what's important is to get that application, which is called your priority application, and that determines the time of protection compared to your your competitors, and it doesn't get published straight away. It will be 18 months, so you'll be ahead of your competitors if you filed first. It's a slightly different process to trademarks. There's a different way of writing the specifications. There's a different type of skill. But
oh yeah, absolutely. Yeah. So with the trademarks, I think we kind of managed to not muddle through, but we found that okay. But this we'd certainly need help in this space. It's beyond us. But I guess
we're happy to have a chat.
It might be worth it just so I can put forward, the kind of stuff that we're doing, and like you said earlier, with software, it's a grayer and harder area. But we're definitely doing novel things, that's for sure.